And the matter before the court is Somerset 24-392, State of Maine versus Michael Kilgore. We are being streamed both by audio and by video on the web. If counsel would identify yourselves by saying your names for the record together with the party you represent.
Attorney Scott Hess for the appellant, Michael Kilgore.
Attorney Sarah Gracie for the state.
Thank you. And Attorney Hess, if you're ready to proceed, we'd be happy to hear your argument this afternoon.
Thank you, Your Honor. May it please the court. The events of September 30th, 2022 were confusing and chaotic. Michael Kilgore, the appellant, was traveling home from watching his daughter play field hockey when he was stopped for speeding by Detective Chelsea Mary. To put it charitably, the deputy was overzealous and described herself as being on high alert when she stopped Michael's vehicle. She approached the vehicle and spoke with Michael and essentially told him that as long as your license checks out, you'll be on your way. The situation became escalated when Officer Mary was confused over the status, I believe it was a condition 6 on Michael's license, and erroneously believed that Michael was subject to having an interlock ignition device installed on his vehicle, and was also associated that mistakenly with some type of bail conditions. She confronted Michael about these beliefs of hers, which again were factually and legally not correct, and essentially accused Michael of lying to her. This escalated the situation, and there were heated exchanges between Michael and the deputy. Contrary to her statements that she would let Michael off with a warning if his license was in order, she wrote him a ticket for speeding, and then, just to add another one on, wrote him another ticket for having an unexpected vehicle. Michael, who was frustrated, drove off after receiving the tickets and accidentally drove over the deputy's foot. This wasn't known to him at the time. The deputy hopped in her patrol vehicle, basically chased Michael down, and he saw the lights and he pulled over. And he looks in the side mirror and sees Deputy Chelsea running at his car with her gun drawn. He was scared. He didn't know what the issue was. She shouted at him something about running over my foot, and then holsters her gun and starts reaching in the vehicle, grabbing Michael, grabbing at his shirt. According to her, she was trying to pull him out of the vehicle, but it was really a melee. Michael was scared, and he drove off, and the officer pursued him at a high rate of speed. After a period of time, the officer stopped the pursuit, but Michael had also kind of calmed down and realized the situation was getting worse, and he pulled down a road. Shortly thereafter, Officer Mary pulled down the road. They had a dispute about what happened after that, but Michael was taken into custody. And ultimately, he was charged with 7 different offenses arising from this stop. Following the presentation of the evidence, the jury was instructed on the substantive offenses as well as the justification defenses. And this obviously leads into the jury instructions, which is really the primary issue in the case. The jury was first instructed as the substantive law regarding aggravated assault and assault on the officer. At the end of that instruction, they were told, essentially, you either find Michael guilty or not guilty. They were then instructed on the justification defense of self-defense, even though they had already been told you basically have a choice to find him guilty or not guilty. The instructions then got into the substantive law.
And that's where I'm going to come in.
Yes.
I see that the green light is on.
Yes, it is on.
So let's talk about the instructions. Sure. There was no request for any different instructions in accordance with State versus Baker, was there?
In State versus Baker, there was at one point a request.
No, I meant in this case, there were no additional requests for instructions or to change how the instructions were given on the justifications.
Not on the justification defenses. There was a request and an objection lodged in regard to the specific unanimity instruction, which has some overlap with the justification defenses. But no, in regard to the structural error, this court is reviewing for obvious error.
There were times, though, when, well, you're saying it's structural error. And is it structural error, or are we reviewing on obvious error?
So in Booker...
Or are they the same?
So obvious error is the heightened scrutiny that the court, or heightened standard of review that the court gives when there's an unpreserved error.
And do you agree it's unpreserved?
Yes, except for the specific unanimity instruction. So we're reviewing, just like in Baker, for obvious error review as to those justification defenses. But just like in Baker, the court found that there was obvious error and reversed in that case, just as the court should do here. And the two structural errors in Baker that are the same errors here are twofold. First, the error was that the jury was essentially given the choice to either convict or acquit after instruction on the substantive offenses.
And I understand what the two different errors are. First, telling them if the state proves the elements beyond a reasonable doubt, they must find guilty without saying go to the defense. And second, telling them the defense elements without saying that you must acquit if the state fails to disprove beyond a reasonable doubt. But in this case, with all the notes, at one point, defense counsel, and I know it wasn't you, but defense counsel says that he agrees to the re-instruction. Is that a waiver?
I believe that was and I don't have the transcript in front of me, but I believe that was in regard to, right, in response to a note that was sent out in that, and I think that was in referencing the specific unanimity instruction. That it agreed, that the attorney had agreed.
Well, it's at the transcript for Volume 2 at page 74.
Appendix 85.
And the defense keeps saying that the concern was, in responding, was they wanted to make sure to put in that the state must disprove beyond a reasonable doubt. And the court says, you're good with that? Yes, as long as it's good, yes. The defense has, yes, I am good with that, okay. That sounds like a waiver, isn't it?
It's not a waiver, because that dialogue was in reference to the specific unanimity instruction.
It's beyond, no,
It wasn't specific unanimity at that point.
it was beyond a reasonable, never did they say you must acquit after. And all the argument from the defense was, no, make sure you say that they must prove it beyond a reasonable doubt.
Yeah. Obviously, the court has the transcript in front of it, but it's not my recollection that discussion occurred in the context of the specific justification defenses as it relates to the structural errors that we're arguing are analogous to.
I'll reply to
Baker.
this and tell them they must consider each of the charges separately. They must consider whether the state has met its burden of proving the elements of the offense in connection with each charge separately. And that is completely their decision. And then read back the testimony. And then any objection. And then he says that there's no objection as long as whether they're proven beyond, whether the state has also disproved beyond a reasonable doubt. I mean, I'm looking at the wrong one. I'm looking at an earlier one. It was the later one. It says you're good with that when the judge said disprove it beyond a reasonable doubt. He says yes.
And if I remember correctly, that was in regard to the note that was sent in by the jury, and the court was concerned about the jury was considering all the defenses and the offenses separately as opposed to consolidated, which would be the unanimity instruction, as opposed to the specific instruction in regard to each of the justification defenses.
But, I mean, we're having specific colloquies as a part of these notes where the only concern that the defense attorney is articulating is that each time they need to be reminded that the state must prove its case beyond a reasonable doubt. Now, not a peep about, and you must acquit, and the language that you're arguing about on appeal. So given that specificity and saying I am specifically good with these responses, how is the judge supposed to sua sponte think that there's something wrong?
So that's why this court is reviewing for obvious error in regard to the justification defenses in those instructions because the objection wasn't lodged at that time.
And you're really
But-
focusing on the original instructions, which in Baker, what we said was that even though there were objections on the re-instruction, we look at obvious error and it's unpreserved because there was no objection to the original instruction.
Correct. But the portion of the transcript that the court is referencing where the attorney said, I'm good with that instruction, right? That followed the court issuing the unanimity instruction over objection without including the language in regard to the also considering the defenses.
Well, so do we, when we see that in response to a note, regardless of the specifics of it, okay? But it's clearly in response to a note, it has to do with re-instruction after the original instructions. Do we ignore that when we decide whether or not the original instructions, which is really what you're objecting to, right, at this point on appeal? You're saying they don't comply with either of the prongs of Baker.
Well, the court never re-instructed on the specific justification
I understand,
defenses.
but it had a general. But what I'm saying is, what your focus is on the original instructions, and that objection is it's reviewed as a structural error, obvious and unpreserved.
Correct.
And it can't, whatever happened in response to the notes doesn't change that, is what you're really saying. We
That's
still have to
cor-
look at
the
the
correct.
original instruction.
Correct. The court still has to review those instructions for obvious error.
But don't we look at the instructions as a whole, and aren't those instructions in response to the notes?
Well, I think if we look at the instructions as a whole, that's one of the concerns in the case, because these different parts of the instructions, when you put them together, they don't make a lot of sense. And I think that's reflected also in the verdict that the jury delivered here, because it's inconsistent. And it suggests that the jury here was really confused by the instructions they
Didn't
received.
the jury still have, even with the re-instruction, they still had the original written instructions, correct? Was there ever any statement from the court that this supersedes my written instructions?
No, there wasn't. But the unanimity instruction was, and I think what the court's referring to, where the note came back about adding in the general defenses, those were oral instructions that were given to the jury. Though that specific instruction wasn't presented to the jury in writing at all.
But you're
So-
not really, I didn't understand your appeal to really be on the unanimity, but more on the way in which the jury was, under Baker, improperly instructed as to the justifications.
That's correct. That's correct.
Okay.
I think we sort of veered off into the unanimity because that was the re-instruction on the unanimity was where the attorney had indicated that he was in agreement with that instruction. It wasn't in regard to the specific justification defenses.
Thank
And I-
you. The red light is on. And I understand, I think you reserve some time for rebuttal.
Thank you.
Attorney Gracie?
Thank you, Your Honor. May it please the court. Good afternoon, Chief Justice and Justices of this court. This case arises from a violent and dangerous encounter initiated by the appellant, Michael Kilgore, during a routine traffic stop. An encounter that resulted in bodily injury to a law enforcement officer, a high-speed chase, and a physical altercation resulting in 2 convictions, assault and assault on an officer. Mr. Kilgore now asks this court to vacate those convictions, arguing that the trial court erred by 1, admitting relevant testimony regarding Officer Mary's injuries, and 2, that the jury instructions were erroneous and contained structural errors. Respectfully, neither claim withstands scrutiny. The trial court acted well within its discretion in admitting Officer Mary's testimony regarding her injuries and about her recovery. That testimony was not only relevant to the statutory element of bodily injury in both aggravated assault and assault on an officer, as well as offensive physical contact and assault, but it also provided necessary context for the jury to assess the scope and credibility of the harm inflicted. It was not unduly prejudicial.
I'm
nor-
sorry, could you just repeat what you just said? I didn't hear.
Yes, it was also provided necessary context for the jury to assess the scope and credibility of the harm inflicted.
Okay, the green light is on. How does it assess the scope and credibility? I mean, either they believe her later testimony that it was worse than it might have otherwise appeared. How does that go to credibility?
I think it confirms her statement that she was in pain. It adds to it.
She says, I was in pain, and I always say I'm in pain. How does my own statement confirm my own statement?
I believe it was just confirming the extent of the pain. She originally stated that she was in pain. She further elaborated on that, describing the spider web-like feeling up her arm, the mentioning of the PTSD in the following months. This further corroborated that she did, in fact, experience pain.
Okay, she said, well, I guess somebody's saying, elaborating on something, I'm not sure how that corroborates something.
Maybe I should have used the word elaborated instead of corroborated in this case.
Okay. Can you go to the Baker issue about the original instructions in this case with regard to the justifications? How does this not violate, and Baker was an obvious error review, right?
It was.
How does this not violate Baker? How is this different?
This case is distinguished from Baker in the fact that there was a mandated not guilty verdict given after the self-defense instruction. The court did give the self-defense instruction and specifically stated that the state...
But there was no such instruction after the instruction on competing harms or duress.
That's correct.
And
After
there's
duress...
three
and-
different justifications that were instructed on here.
It was given after the self-defense. After the other two defenses, it was mandated that the state must prove these beyond a reasonable doubt. So although the court did not use a specific acquittal language or not guilty verdict
Isn't it
language...
clear that the jury was confused because they weren't even sure what these justifications applied to what count? I mean, the way it was done, he gave the instruction on the ag assault, self-defense, assault on an officer, self-defense, then instructed on all of the others, and then way at the end said, oh, and by the way, there's this thing called competing harms and this thing called duress, and never related it to any specific offense or what they were supposed to do with it.
I think
It's
the...
actually, isn't it actually worse than Baker?
I don't think it's worse than Baker. I do think the order that the instructions were given may cause some confusion. That being said, I think the overall instructions seen as a whole did complete their purpose
Well,
and did provide...
the jury's third note read along the lines of, does being under duress change the outcome of guilt? Doesn't that tell you they didn't know whether the state had to prove beyond a reasonable doubt that Mr. Kilgore wasn't under duress?
I don't think it changes the fact that the state had to prove it beyond a reasonable doubt. I think that might go back to whether duress applied to all of the charges, which I think the judge or the trial court in this case did do a great job of reiterating multiple times that all of the defenses do apply to all of the charges in this case. Although it may have been done out of order, I do think that was accomplished here.
But when he talked about duress and competing harms, I mean, the language is significantly different than what he did with self-defense. And for duress simply says, person is not criminally responsible. State must prove beyond a reasonable doubt that the defendant was not acting in duress, but no pathway to an acquittal, no saying you must acquit when you find that. And same for competing harms, talked about that, and all the judge says about that is the person is justified. In other words, the justification applies. So you have self-defense, pathway to an acquittal, you must acquit if you find evidence disproved it, but none of that for duress and competing harms. Isn't that problematic? And the jury is figuring, okay, well, we know if it's self-defense and they haven't disproven it, we must acquit, but you didn't tell us the same thing for duress or competing harms.
I think it has the possibility of being problematic. I think in this case where the court did specify that it must be proven beyond a reasonable doubt, I think that clarifies, although it doesn't use the acquittal or not guilty verdict language.
But that's the key to it. I mean, the burden, he clearly states that the burden is there, but it's the pathway to the must acquit, must find not guilty that is missing, that I think is the tipping point, maybe a tipping point here. How do we reconcile that?
I believe because it was given in the self-defense instruction, at the end of the self-defense instruction, I think the jury reasonably could have applied that to both of the duress and competing harms defenses as well.
How would they know to do that?
I think because it was given the instruction that it must be proven beyond a reasonable doubt to be found not guilty in this case, or not guilty, that language wasn't used, but must be proven beyond a reasonable doubt. I think the jury reasonably could have applied the same instruction that was given for self-defense to competing harms and duress, understanding that all three were defenses and all three of the defenses were supposed to be applied to all of the charges in this case.
I'm just looking at this, perhaps most likely in your favor. Looking at the instruction for duress, line 7, judge says, I'm quoting, I'm going to discuss a couple of defenses that are applicable to all. All defenses are applicable to all of the offenses that you'll have to consider. Can you argue that that sort of swept in the previous defenses he talked about and gave that same directive by that cumulative language heading into it?
I think it did attempt to include all of that language at the end there. Could it have been done more succinctly? I think so. I think in this case, the judge could have reiterated that all of the defenses needed to be proven beyond a reasonable doubt, or there would be a not guilty verdict. In this case, that was not done here, but I think including that language that all of the defenses equally apply to all of the charges sort of accomplished that goal in a roundabout way. And again, we are looking at the jury instructions as a whole, as given by the court in this case.
Does the state, when the state hears instructions coming in a problematic way, does the state have a duty to step up and say to the judge, oh, okay, you hit the burden of proof and that this is a justification, but you said you must convict if they hit the other elements of the offense. Here are additional elements, but you didn't say you must acquit if they fail to apply those.
I think the state does have a duty to speak up if it's noted that that had happened. In this case, neither the defense nor the state spoke up and made any comment on that specific instruction or lack of instruction in this case, but I do think the state has a duty to speak up in the case that there's an instruction missing or misstated. If there's no further questions, I'll conclude my argument. Thank you.
Attorney Hess?
Just briefly, Your Honor. Jury instructions are the backbone of our criminal trials and the jury system. And it's really important to keep in mind, right? Like what these instructions do are providing a pathway for lay people who are not lawyers to navigate complex laws, right, and reach a verdict. Justification defenses are probably some of the most complicated instructions that we have in criminal law, right? We spend a lot of time with them as judges and lawyers drafting them and understanding them, which makes it all the more critical that those instructions be accurate and they be clear and they provide the jury with an accurate pathway to whatever verdict they should reach.
Can't disagree with any of that. Can you just, this is a little off topic and I don't want to take too much of your rebuttal time, but what was the argument about competing harms? I'm looking at the factual scenarios to what happened here, and what was the argument that competing harms would even apply?
Sure. So I think the argument was, given the officer's conduct, that Michael was afraid he was going to get shot or really hurt by the officer, and that fear was reasonable, and that the harm that was generated by violating the law was outweighed by the need to avoid the harm of being subject to, I think, the unlawful use of deadly force.
Okay.
But we can't, we can't expect the jury to find their own pathway through a roundabout way when it comes to instructions, and especially not instructions on justification defenses. Thank you.
Thank you. Thank you, counsel, for your argument in this case. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. In addition, we have a tradition of inviting new counsel back to meet with the court, and we would invite both attorneys back to take the greetings of the court today. I understand, Attorney Gracie, this is your first argument.
All rise.
be seated. And the matter before the court is Kennebec 24-447, State of Maine versus Heather Hodgson. We are being streamed both by video and audio live on the web. If counsel would identify yourselves by saying your names for the record, together with the party you represent.
Attorney Scott Hess, I represent Heather Hodgson, the appellant.
Shannon Flaherty for the state of Maine.
Thank you. And Attorney Hess, if you're ready to proceed, we're happy to hear your argument this afternoon.
Thank you, Your Honor. May it please the court. Heather's appeal challenges the sufficiency of the evidence that for the basis of Heather's conviction. In addition, the state has cross-appealed on the denial of the Rule 35 motion and argues that the trial court erred in failing to impose.
It's not really a cross-appeal, it's an appeal that we consolidated, right?
That's correct. That's correct. It actually was the Rule 35 motion is a collateral attack, if you will, on the sentence that was imposed by the trial
Well,
court.
counsel, what other recourse would the state have but to bring a Rule 35 motion, and if that was properly brought, don't they have a right to appeal it?
So this is one of the primary issues when you ask what was the recourse the state had. The recourse the state had was to appeal in the first instance.
But can they do that under Section 2115-A of Title 15, which limits what the state can direct appeal, one of which is a Rule 35 denial, one of which is not an appeal from a conviction or a sentence?
I'm not sure, Your Honor. I don't have that statute right in front of me.
Let me suggest to you that that's what the statute says.
Okay.
Let me jump to the merits if I can.
Sure.
A person in a highly agitated state who's intoxicated and points a gun, a loaded firearm, at another person, trains the muzzle on them, this is what the evidence in this case showed, correct? And then diverts it briefly and shoots within inches of their foot. How is that not use of a firearm against an individual?
Because the bullet did not travel at Mr. Hodgson. If you almost had a Venn diagram, okay, you could certainly have circumstances where a person
Are you suggesting
could
he has to be hit by the bullet in order for it to be a firearm used against him?
I think so part of the problem here, though, is the indictment does not say that the firearm was used against Shane Hodgson. This is one of the issues with imposing the mandatory minimum sentence, is because the indictment tracks the reckless conduct language that says that Heather recklessly created a substantial risk of harm with the use of...
It says to Shane Hodgson with the use of a dangerous weapon, namely a firearm, committed against a family or household member. That's what count 3 says.
Recklessly creating a risk is not the same thing as using a firearm against a
So
person.
you seem to be suggesting you have to actually have the bullet hit the person in order for it to count.
Yes, the firearm has to be used against the person.
Well,
And
I'll
I
just-
believe that that is appropriate.
When you say, okay, let's say she shoots at him and misses, is that a firearm used against a person?
No, it's not.
So there could never be a substantial risk of harm with the use of a firearm, because there has to be actual harm, in your view.
There would have to be the weapon directly being brought to bear on the individual and around discharged at them.
But she was bringing a weapon to bear against him. She was trying to stop him in his tracks. She was using that as an instrumentality against what he was about to do.
That is still not using a firearm against an individual.
So go back to your Venn diagram then. Draw for me what use against an individual entails.
So by way of example, if an individual, say, was robbing a bank and there's a security guard and the security guard is shot but has a bulletproof vest on, doesn't suffer any bodily injury, that would then be using the firearm.
I've got
against
my
the person.
handgun up against his head and say, unlock the safe. I'm not using a firearm against that individual?
Not in the way that the statute.
Where do you
Under
see
these
that in the
circumstances.
where do you
And so-
see that in where do you see that in the statute? It just says used against an individual.
It does. That's correct.
I have a
As opposed-
firearm, as the chief said, it's up against your head. That's not used
But
against you?
the indictment does not say.
No, I'm not
that
asking
you-
about the indictment. I'm asking for your definition of use against an individual.
So in the statute, it also excludes from the one-year mandatory minimum enhancement offenses that would
Right,
constitute.
threatening or terrorizing,
Right,
but it doesn't
correct.
exclude this offense.
Right. But that conduct that you're describing under the different scenarios, essentially threatening somebody
Well,
with a
Counsel,
firearm, is more
the state-
analogous to
The
those.
state cited Napier in its brief, and I went and looked at the case. Sometimes you do that. And it talks about the fact that the liability for reckless conduct turns on the creation of the risk, not actual harm.
Yes, but that's why the enhancement under the statute to impose the mandatory one-year mandatory minimum goes beyond just creating the risk. It involves requiring the state to plead and prove that the firearm was used against a person. Just creating the risk of harm with a firearm does not automatically trigger the one-year mandatory minimum
But
sentence. I
Napier
mean,
goes on to say that pointing a loaded gun at a person created the risk that the firearm might be discharged. So that's use of the firearm, is it not?
No, it's not. That's creating a risk. It's not the use of a firearm against an individual.
Well, how is the risk being created absent the use of the firearm in that circumstance?
The presence of the firearm and the possibility that it could be used
Which
against a
means that
person.
one is wielding or holding a firearm and pointing it in someone's direction that thereby creates the risk, does it not?
The pointing the firearm creates the risk, but that, again, where our position is that is not the same thing as using a firearm against an individual.
If I go back
The
to-
language is different. And Klein specifically notes that the indictment in Klein, the prosecutor alleged that the firearm was used against an individual here.
That's
And
a
that's
If I
very
can
di-
go
that's a-
back to Justice Douglas's question earlier. Let's say the indictment did allege the language that you're asserting here. If the person used the firearm to modify a person's behavior because they've got a gun, does that satisfy use against the person?
No.
They
No?
have to be shot.
But
The-
the firearm...
The applicability is much more narrow.
But what you've done essentially is you've written out of the law reckless conduct. Because if I point a firearm at somebody, if it hits them, aren't I intending or at least knowingly using that firearm against the person? Under what circumstances would a reckless act be implicated?
Well, conversely, based on the questions of the court, every time a firearm was involved in the offense of reckless conduct, it would automatically trigger the one-year mandatory minimum.
Well, no, that's not true, and Klein is a perfect example of that. And Klein's a very different case. The guy was in his backyard, the defendant was in his backyard target shooting, and the bullet went toward his neighbor's house, and it actually struck the neighbor. But that's a very different situation. There's no other individual in the picture, so to speak. I understand that.
Yep.
But here, it's a direct use against another individual.
The indictment does not plead that the firearm was used against a person.
Well, the judge here found that the indictment was satisfactory, correct?
I think that this court would review the sufficiency of the indictment de novo when it comes to whether or not the language in the indictment says the firearm was used against a person. The indictment says that a risk of harm was created with the use of a firearm, not that the firearm was used
And
against the
then
person.
says the conduct was committed against a family or household member, which is the exact language you're concerned about.
The recklessness occurred.
Says the
Yeah.
conduct, meaning all of it, was committed against. I mean, what language is missing?
The use of the firearm against an individual, just like in Klein, that specific language that's referenced in the statute is missing from the indictment.
Does the sentence enhancement then turn on whether the language, putting us, given the judge's findings, does it really turn on whether, essentially as a matter of law, based on this language in the indictment, that the one-year mandatory minimum applies? Because, I mean, the judge said, well, I guess I didn't really find it as a matter of fact, and so I don't, but et cetera. So for us, does it turn on whether this language is sufficient to invoke the mandatory minimum or not? in the indictment?
No, the case does not turn on whether just the language in the indictment is sufficient. The state also has to plead and prove the charge, and the judge himself said, I did not consider this essentially element. I mean, the enhancement is, for all intents and purposes, an
But
element.
if we say, if we were, so that's a little bit maybe getting to where I'm going then. So if we were to say that this language in count 3 is sufficient to invoke, and does indeed invoke the mandatory minimum contained in statute, doesn't that mean that the trial judge committed error when he found that this offense was committed by not imposing that mandatory minimum?
No, Your Honor.
How do you parse out of that? I mean, haven't we said if you find the defendant guilty of this offense, and if this charges that, and I know you disagree that it does, but if this charges sufficient that it requires the mandatory minimum, how is that not error on the part of the judge?
Sure. So for two reasons. The first reason is that, like and I think Klein recognized, and granted it was a jury trial, but that specific question had to be presented to the jury, and I think in that case they used a special verdict form. So the fact that the court really didn't even consider that in the deliberation is reason number one. Reason number two, and this also goes back to the indictment, is that the indictment only cites one of the two enhancements. Now, I'm familiar with Woodard, that came out right after
I
I
know.
wrote
I
the
know it was
brief.
after you wrote your brief, so.
Yes. And so there's a due process issue, though, that was created. If the state didn't cite any enhancements in the indictment, then perhaps we wouldn't have this argument. But the state cited specifically one enhancement to elevate the misdemeanor to a felony. It didn't cite the enhancement to impose the 1-year mandatory minimum. And that
Isn't
says
that
it
because
was
the
misleading.
second goes to sentencing, whereas the first goes to the actual charge?
The state still did not, charges that, or elements, statutes that enhance mandatory minimum sentences are essentially part of the elements of the offense, right? This goes back to the Apprendi line of cases where you have to treat any enhancement as if it were an element of the offense and plead and prove it. So the fact that the state specifically cited one enhancing statute and omitted the other enhancing statute creates a due process issue that I think needs to be reconciled in favor of Heather.
Thank you.
Thank you.
Attorney Flaherty, we're happy to hear your argument.
Chief Justice Stanfill, Associate Justices, may it please the court.
Counsel, the green light is on.
It is.
I have a pressing question I want you to answer.
I'm ready.
Do we have an Apprendi problem here?
I don't think so.
Why not?
I have struggled, and I think it's clear from the transcript, with this argument from the beginning about what's supposed to be in the indictment, what the indictment actually says.
Put the indictment aside here.
Okay.
Do we have an Apprendi problem because the trial judge did not make a finding beyond a reasonable doubt as to the sentence enhancement?
I would say no, because in Woodward, the sentencing enhancement is not an element of the crime. This is not an element. We talked about this as if this was an element of the crime. That is not an element of the crime.
What about Alene? Alene versus the United States, or United States versus Alene? I'm not sure which it is. Pretty much said a sentencing enhancement for all practical purposes is an element of the crime and has to be proven in a jury trial beyond a reasonable doubt to the jury. Here we have a bench trial where the judge at sentencing said, I don't think I made that finding, and at the Rule 35 proceeding, went back, reviewed the entire record, and said, you know what? I didn't make the finding I need to make.
When I go back and I read that transcript, I asked Justice Stokes multiple times during the original sentencing, are you saying that you did not find her guilty of reckless conduct with a dangerous weapon? He said, no, she is guilty of that crime. The only thing he said that he did not find is that he didn't say the phrase against an individual.
Well, is it possible to commit the crime of reckless conduct with a dangerous weapon, a firearm, without using the firearm against an individual? Is that possible? In other words, I think Mr. Hess said at the beginning, think of a Venn diagram. put the Venn diagram up there. Don't you have to have complete overlap in order for your position to prevail? Are there circumstances, in other words, where a use of a firearm against an individual is not necessarily a component of a reckless conduct with a dangerous weapon charge?
I'm not remembering the name of the case, but I do know that this court has talked about reckless conduct against the general public and that there are some concerns about that being within the indictment. But I have to go back to this case, and the indictment and the facts are against Shane Hodgson's. They keep saying that we have to say, are we supposed to say the individual Shane Hodgson's, the individual who happens to be a person, Shane Hodgson?
So are you saying as a matter of law on these facts, this is use of a firearm against an individual? Because we have a trial court, we have the fact finder here saying, I never found that fact.
It's very confusing when you read Justice Stokes' sentence and then his verdict, and you compare them and the Rule 35, because he says over and over again, I do find that she shot a firearm off at her husband. I just did not use the phrase. That's what he focuses on. I did not say against an individual.
So that brings me back to sort of the same question I guess I asked Mr. Hess, which is, as charged in this case, and obviously, reckless conduct, even with a dangerous weapon, could have been charged differently. It may not have mentioned a specific victim, it may have been the public at large, et cetera. But in this case, where it was create a substantial risk of bodily injury to Shane Hodgson with the use of a dangerous weapon, firearm, and there's no question that the only weapon here was a firearm, and that this conduct was committed against a family or household member, does our decision need to turn, given what Justice Stokes said, on whether, in this case, that charge, as a matter of law, invokes the 1-year mandatory minimum?
Are you saying between, if you didn't have the family or household part, would you still?
I'm just doing the whole thing.
Doing the whole thing?
Taking it as a whole.
As a whole.
And what my concern is he says, well, gee, I really didn't find that. And if we defer to that as a finding, I don't know that we reverse. And so then the question becomes, isn't the question really whether, as a matter of law, as charged in this case, it invoked the 1-year mandatory minimum?
I think the answer is yes. And I think it has to be yes, because when you read the indictment and then you look at the case, because Mr. Hess is right. The state has to plead and prove its case. That's how we get to certain mandatory minimums. That's how we prove the case beyond a reasonable doubt. The indictment states in two different sentences, it's against an individual, either Shane Hodgson as a person as an individual or a family or household member as an individual. When you read the verdict, Justice Stokes says that the defendant shot a firearm off at her husband or in the direction of her husband. I don't know how to get around that. And I understand the confusion.
No, I think Mr. Hess is saying it has to hit him.
And I firmly disagree with that. And the hypothetical that I thought of on the way here is this situation is very similar. If we were in the Old Port, and I don't know, I'm sure we've all been, I don't know, maybe you guys have been there. But after hours, at night, after the bars have closed, people are always in the streets, right? And there are people and the roads are closed. If someone drove by the Old Port and there are people outside and they're shooting a gun off at their feet, is that not reckless conduct? Because that's exactly what happened here.
Well, reckless conduct, but against a person with the use of a firearm is what you're saying.
Right, there are people out there, they're leaving foreplay, and someone's shooting at their feet. Is that not reckless conduct with a firearm? Because that's exactly what Ms. Hodgson said
Is
here.
this case unique because it was tried to a judge? If it had come to the sentencing, and they're about to sentence there, and the judge said, I'm going to impose the minimum mandatory, and defense says, wait a minute, there's no finding here, it was a firearm used against a person. Could the judge have said at that time, I'm the finder of fact, I find that it was used against the person, I'll use the magic language. I mean, it sounded strange to me. He said, I don't know if I made that finding. Let me review the transcript of my own statements, and I'll see what almost like he's looking at a jury decision there to see if the jury reached that. But doesn't the judge, up until the point of sentencing, have the prerogative to make that find? The judge who heard the case have the prerogative to say, yes, this was the use of a firearm against the person.
He does, and that's why at sentencing I kept asking him.
But he didn't.
I know, I understand that.
And so let me also turn the question a little this way. If this had been a jury trial, and there was no special verdict form with that question on it, would we be here today?
I'm not sure.
On your appeal, I mean.
On my appeal, I know, we're
On your
talking
appeal,
about mine.
yeah,
I get a little
yeah.
confused because usually we don't get to
I mean,
appeal on the
isn't-
state end. But
Isn't that what Klein says?
Klein does say that, and I think the difference is in that case, the state agreed that there was nothing presented to the jury, that there wasn't enough information either. It's a little bit unclear if it's just the facts and circumstances or the special verdict form, if I'm correct, and I might not be.
So going forward, if we were to, let's say, in this case, hold as a matter of law on these facts, this is reckless conduct with use of a dangerous weapon, a firearm used against a person. Going forward, how do trial judges, what do trial judges do with that in future cases? Do they read that to say they don't have to give special verdict forms to juries? Do they do it, would you be doing it anyway?
Best practice with juries, in my opinion, is to do a verdict form, especially if there's multiple elements that have to be met.
Do you agree that in this case, you would have needed to use a special verdict form?
I don't think we would have needed to. I think it would be best practice to. I think that a jury could still find without a special verdict form that based upon the evidence that a firearm was shot off at an individual. The entire case, all of the facts and circumstances, this is not like there was a debate about whether she shot the gun. Everybody agrees that she had a firearm, she was a trained firearm expert, and she deliberately shot at her husband. If the facts were a little bit different, if we're talking about a BB gun, I know there were some cases before the law court, before you all about different types of weapons, is it actually a gun? There is no doubt here on either side that she shot a firearm off at her husband. If this were in front of a jury, I don't think you would need a jury form because there's no question if it's the same evidence.
That brings it back to the charge as it is.
Right.
Is sufficient that if you find each and every one of those elements beyond a reasonable doubt, you are finding that this firearm was used against an individual.
Exactly, which is what Justice Stokes found.
When are we dancing on the head of a pin? Because when you go back and you look at it, Justice Stokes is saying, I didn't make that explicit statement. But he says, I think it's pled properly. I think you can argue that. And then he goes on to say, well, I didn't make that finding explicitly. I made it implicitly. As long as he makes the finding, isn't that where we need to be?
I agree. I've agreed from the beginning. I have been confused a little bit about this case. I had to look up what individual means. I had to look up the definition. I thought I was losing my mind. It's just, yes, he says several times over and over again that he found her guilty. And if you read the transcript from the sentencing, even though I obviously didn't want him to take away the guilty verdict that I had received, I in many ways said, if you're confused about what your verdict is, then do what you need to do with that. But then he came back after listening to the entire transcript and said, no, she's guilty of it. I just didn't use the phrase individual. I just think that's bad practice and that we do need to do that. The only thing I did want to put on the record is about the Rule 35 motion. I agree with the statute. I also agree with State v. Johnson. The Rule 35 is not something that only the defense can use. Appeals are very specific when it comes to the state. We have to ask for permission to even appeal. And I believe this is in the record from the Rule 35 motion. I reached out to the Attorney General's office, and they told me that this is the process and that this was the best course of action. I do know there was a lot of talk about if I did it within 21 days, it doesn't really matter, but
I'm going to suggest the statute
I think I'm okay.
pretty much takes care
I
of
just
it.
wanted to
Sorry.
mention that, and if there are no further questions, thank you very much for your time.
Thank you. Mr. Hess, I just didn't want you wasting your valuable time on that issue.
Appreciate that, Your Honor.
Or what I view. I don't know what my colleagues do.
I mean,
Time is precious in oral
what I
argument.
think the state is saying is the finder of fact did not have to use special magic language because all the relevant findings of fact were made, whether implicitly or implicitly doesn't matter. What's your response to that?
My response to that is that the fact finder does have to make a finding that the firearm was used against a person. And
It can
Justice
be
Stokes-
implicit, right?
Does it have to use those words is the question.
If it were a special verdict form, you'd have
In
those
this
words.
case,
You had the court who articulated on the record its verdict. If that was part of the court's verdict, it should have been specifically articulated on the record.
But then it was articulated when he says, yes, I'd made that finding implicitly. Doesn't that put the nails in the coffin right there?
No, it doesn't, because...
That's a finding.
The verdict had already been issued. That was the court reflecting upon the matter at sentencing.
He's saying what
And I
he
think-
did and what he found. We don't look at that?
Well, you know, I think one of the due process, going back to and this ties into your question, looking at the due process issues, Justice Stokes didn't even know this was an issue. Didn't even know the state was seeking a mandatory
If we're
minimum
going to talk
or
about
minimum
due
enhancement.
process, where were you prejudiced?
Because the approach
Did you have
the defense,
inadequate notice? What would you have done differently at the trial or the sentencing?
So that could have been approached differently at
How?
trial. I wasn't trial counsel.
You weren't, but don't you have to identify for
I
a due
wasn't,
process?
but so
how-
that might have resulted in a decision to retain additional experts in the case to determine, you know,
That when
the
she shot
ballistics.
towards his feet, it wasn't shooting, he
Well,
wasn't using a
like was
firearm
argued
against
Justice
him?
Stokes, right? Like in the direction of, there's a big difference between, Shane is at 12 o'clock and the bullet's at, 12:30 versus,
Well, the bullets
4
actually
o'clock.
hit at 12:01.
It's not clear where it hit because no.
Well, he said
no-
within
He said
inches
within
or at most a
inches.
foot.
He said within inches.
So I guess on the finding issue, going back to that, it seems clear, at least on the record, that he didn't consider that particular issue when he rendered the verdict.
Correct.
And then later, when it was pointed out, he reviewed his language there, and of course, he knew it was in his head too, and he says after the fact, yes, I may not have said it out loud, but I meant it, it was implied in my findings. How is that not a finding that would support the imposition of the mandatory sentence?
So I think the court made the finding that Heather had committed the act of reckless conduct. The court, I think, indicated they didn't specifically consider whether the firearm was used against a person, which again, the defense could have argued, just like I did before you all today, in terms of what would have been done differently, that distinction in the language.
Thank you.
Thank you.
And thank you for the argument here today, counsel. Always a pleasure to have both of you here. I note, Attorney Flaherty, you seem to be coming as a regular now there.
That was a less than
It wasn't-
enthusiastic,
It
yeah.
wasn't very long ago that you had your first argument.
At my high school.
Oh, yes.
Yes. But in any event, we will, of course, as is our usual practice, take the matter under advisement and issue a written decision in due course. And with that, we are in recess for today.